Hi viewers, my name is Josue Rosario. I'm a legal intern here at Stein IP LLC. I'm here with Michael Stein, principal of Stein IP LLC. We're going to have a brief discussion about how software and intellectual properties align. Michael, care to give out a bit of background information to our viewers?
Thank you for the introduction. I've been practicing for about 30 years now. Most of my practice relates to patent acquisition, some licensing, and enforcement issues. I have an electrical engineering background and been working with clients. A significant part of my practice relates to protection of electrical inventions as well as computer software and the interaction between those two areas.
Perfect. Seems like you got extensive background working with software and working with technologies. Can you give a small explanation of how IP and software actually align, how intellectual properties actually help software and be protective from infringement or theft?
As everybody knows, in the last 20 years or so, there's been an explosion in the development of software. When I first started practicing back in the early 1990s, there was very few patent applications being filed, very little notion of protecting software. There were a few applications to that. The USPTO didn't know how to handle it. Generally, they said they felt it wasn't the subject matter for patents, just because they hadn't really seen much of it. And then towards the latter part of the 1990s and then into around 2010, maybe 2012, it became very easy to protect intellectual property and acquire patents. And some of the patents were just kind of ridiculous. I mean, they related to one piece of user equipment and another piece, and communicating between the two. And as software became a bigger part of society, some cases came up to the Supreme Court, and the Supreme Court started to ratchet back what was permissible or patent eligible.
For softwares, yes. I'm guessing that's due to the lack of prior art during those times. Another question for you, Michael. What's in your professional opinion the best way to actually protect your software? I know there's a couple of ways given by the USPTO office, but I want to hear from you. What do you think is the safest way for potential applicants to protect their software?
I don't know if there's a safest way. As I tell people, intellectual property is not just a legal document, but a business document. So I'm always asking, what is your purpose? What are you seeking to protect? What is unique? And that response makes me be inclined to seek one way or another. So generally the major areas are utility patents, second area is design patents, third area is copyrights, and the fourth area is trade secrets.
Okay. You mentioned two types of patents. You mentioned design patents and utility patents. Can you care to give out a little bit of difference in between two?
For utility patents, those generally relate to the functionality or the technical components of an invention. And so if you look at concepts such as processing information and then locking a door or setting off an alarm or making the car rotate if it feels like it's about to go off the road or someone's in your blind spot, those are functional improvements. If it relates to how you use less storage space in a database, or making your computer faster or using less energy, those relate to functional benefits. And for those areas are generally what people seek utility patent applications for.
And for design patents, what's the...
For design patents, it's more the look and feel of how the software is used. And when it comes to that, if you look at, there was a huge patent infringement case relating to the shape of the Apple iPhone, and whether Samsung had infringed upon that. And so it's just how the edges looked.
Okay.
It could also be the Google search bar, the appearance of that. There's also, I know there's a design patent applications on just when you turn on the home screen of the Apple, how the applications are set up.
So the user interface of the app, of the iPhones and Apple products, because most of them look alike. So I'm guessing it's just the design patent for that. It's applied to every device Apple made with the same interface.
Yeah, I mean, it could be subtle distinctions. You know how when you have different windows and you have I don't know, the shape, and as you peel through the windows,
Yes.
even something like that, which you don't even think about, but it was intentionally done in that way to give the appearance of flipping through pages.
Okay, that's interesting because, as you just mentioned, pens are practically living with us in our day-to-day life. Everybody, most of the population in America has iPhones, has Samsung phones, so that's curiously to know because that's how intellectual property, especially pens, are integrated in our day-to-day life, especially software pens. Something as simple as you mentioned is the interface, scrolling through pages when you close in on windows, and they look like actual pages. Puts a person in perspective to see how utility pens and design pens are integrated in our day-to-day life.
Yeah, let me just say before you go on that I would say the vast majority of patents relating to software do relate to utility patents.
Okay.
And that is generally because you get, for most inventions, a broader scope of protection. So if you have a certain functionality, it protects even if someone does that functionality in a different way. And I would say, I just saw some chart. It was basically an asymptote of the increase in the number or the percentage of patent applications, utility applications that related to computer software. And I think as of a couple of years ago, the percentage was like 65% or so, or even more, relating to computer software in some way.
Yeah, it is indeed a booming business, something that's really been innovating through the last couple of years. There's new technologies being advanced every day, so there's potential market for new patents there, design utility patents. You also mentioned something about copyrights and trade secrets. Care to elaborate a bit more on that?
Yes, with respect to copyrights, which is not part of the U.S. Patent Trademark Office, but it's under the Copyright Office, which is within the Library of Congress. Copyright protection generally relates to, when you're talking about software, to the lines of code and how the code is written. And in that regard, that relates generally to more specific copying of, hence copyright, specific copying of the code. And for that, you need access by the potential infringer. One of the benefits of copyright, in spite of the limited protection, is you get copyright protection once it's fixed into a tangible medium. And by tangible medium, that could also be on a disk or in a storage that's transfixing it onto a recordable medium. But in order to infringe, in order to sue for infringement, you need to file for a copyright registration in the U.S. Copyright Office.
Same with patents, and I'm guessing design utility patents. You got to apply for them to be able to sue somebody for infringement.
Right, with patents, unless you actually get a patent, you have nothing.
Yeah.
With copyrights, you get some protection, but you will get more protection when you actually file the copyright registration.
And for trade secrets, what's your take on trade secrets?
Trade secrets, a lot of companies, especially when it became more difficult to acquire patent protection on computer software, more companies and even individuals started to, and universities started to consider using trade secrets. With trade secrets, basically you are, as the word say, is you are keeping your technology a secret. You're not giving out what the code is, you're not giving people access to how the functionality works other than what people see when they deal with it. In order to have a trade secret, there are certain factors that you need to employ. That includes treating it as a trade secret. It includes giving only limited access to people, having a policy on what can be done with that. So efforts need to be made in order to keep it a trade secret. One of the benefits is a trade secret can last forever. Not specifically related to computer software, but probably one of the most famous trade secrets is the formula for Coca-Cola. And that can last forever. And but one of the downsides is if it gets stolen and it gets out there, you can sue the person or the party that stole it, but it's out there. Or if someone independently designs it, then you do not have protection.
So if somebody curiously stumbles upon the same formula, they don't have protection over that?
Well, I mean, curiously sounds, you're giving it an implication of sinister. But, I mean, there's plenty of inventions that people don't just innocently. I mean, if you're in the field of cybersecurity and you're looking to prevent a certain type of cyber attack, it wouldn't be outside the realm of possibility that another party is seeking to solve the same problem. But when you start looking at it where the way they do it is very particular, if you have circumstances where a former employee now works at the new place, if you had a non-disclosure agreement for some development and all of a sudden they come out with it. So there's indications to indicate that the development wasn't independent.
You mentioned benefits for copyrights and trade secret. Any benefits for patents, design patents and utility patents, apart from the obvious one of having to protect your asset? Is there anything more above from that?
Well, protecting your assets is huge, and I wanted to say that for patents, for utility patents, the length of protection is generally, without getting into some complexities, 20 years from the date of filing. And with respect to design patents, it's 15 years.
Okay.
But with patents, particularly utility patents, you can get some pretty broad protection. Especially when you're talking about the functionality of something or the method of doing something, even if the exact way to perform the particular steps might be somewhat different. So let's say someone uses a different formula, but it achieves the same result. And therefore, even though the length of time might be shorter, you can get often much broader scope of protection than you could either through copyright or the risks that are involved with keeping something a trade secret.
Keeping with along the lines of benefits, is there anything our potential viewers, potential patent applicants should keep in mind before applying for any patents or any trademarks? Copyrights?
Well, with respect to copyrights, because protection starts when it's affixed to a tangible, readable medium, the risk of loss of rights is not really present. When it comes to patents, there is something called an on-sale bar. And so in the United States, which is actually somewhat lenient, if you disclose or offer for sale of the product you have 1 year from that date in order to file a patent. Otherwise, you lose the ability to file for a patent application, and that technology can go into the public domain. So, a big word of caution from my point of view is to, before you actually market it, to consider seeking patent protection, consult a professional in that regard. With the United States, as I mentioned, it's somewhat lenient, so you get a 1 year grace period, but in many countries, and in fact most countries in the world, they either have no grace period or a grace period with limited exceptions. So if, let's say, you sold August 1 in the United States and then you didn't file until October 1, you could still file in the United States, but you might lose the right to file internationally.
Is there any difference between filing for software patents within Europe and the United States, or is it the same process? Is it different scopes of protection?
What is considered patent eligible, it's different in Europe, and it's different in China, it's different in Japan. And so one of the questions I initially ask people is, do you plan to seek international protection? Because a patent should be drafted then in a way that you can get protection in not just the United States and other countries. At this point in time, and of course it's subject to change, the United States is actually one of the more difficult countries in which to acquire software.
Oh, wow. Do you know any reasons behind why it's more difficult to file patents, acquire software patents or any type of patents here in the States than it is in Europe or China?
It's basically because the U.S. Supreme Court says that's the way it should be.
Okay.
The patent statute relating to patent eligibility, what's eligible, I think it's a very short section of the U.S. Code, 35 U.S.C. 101. It has not been amended since, I believe, 1952. And so it's the same words that are being applied, but the way the courts apply them, and then in more recent years, the Supreme Court used the concept of abstract idea. But abstract idea is not even in the statute. That was basically court implemented. And so, as I mentioned before, back in the 1990s and early 2000s, it was relatively easy, and that's because of some Federal Circuit decisions, and the Supreme Court did not get in the way. They didn't think it was very important. Just to give an example of the increase in importance of software is, when I first started practicing, if the Supreme Court took up a patent case or any type of intellectual property case, it was maybe once every couple of years. Now, every year on the docket, there's multiple cases. So, Congress is talking about making changes to make it somewhat easier to acquire patents, or at least make it more certain as to what is patent eligible. But as you and many people know, it's very difficult for Congress to agree on anything, even whether today's Monday. And so change comes slow. And the U.S. Supreme Court, since the 2014 Alice versus CLS decision, which basically said a bank method for balancing accounts at the end of the day was an abstract idea, the Supreme Court has been denying certiorari for all of the cases that are brought up from the Federal Circuit.
Well, that wraps up our first podcast video for today. Thank you for Michael for letting me host this first episode of the Stein IP podcast. I hope there's more episodes to come, and I'll see you, our viewers, in our next episode.
There will definitely be more episodes to come. It's been a pleasure being interviewed by you.
Pleasure being here.
All right.
Thank you. Hey.